On PM Express tonight, testing the RTI law, the new phase of the struggle for implementation. You may be following the conversation because there's fresh calls for the RTI law to be fully implemented as the first test for the law hits a snag. You may be following the conversation throughout the day that a member of parliament for Ashama, Ns. Nogbe, attempted to access information on whether the EC has procured the services of Dr. Oforeje, an IT consultant, and A. Akrofi, a procurement consultant. And he continues to say that if the above was in the affirmative, I mean, if the response of the Electoral Commission is in the affirmative, then the MP also wanted to know if services of the consultants were procured in accordance with Part 6 of the Methods and Procedures of the Public Procurement Act 2003, Act 663, as amended. He also asked for a copy of records of procurement proceedings as required by Section 28 of Act 663 as amended. Now, the EC, in responding to his request, in a letter written to the Member of Parliament for Ashaman, said, per Section 75(1) of the RTI Act 2019, Act 989, the EC is unable to provide the information being requested for by the MP. It continues to say that Section 75(1) of the RTI Act provides an applicant seeking access to information under this Act shall pay the fee or charge approved by Parliament in accordance with the fees and charges. Now, the EC says it can only provide the information the MP is looking for when that fees and charges have been determined in accordance with the law. In other words, Parliament must be able to determine how much should be paid for the information that you ask for. But the coalition for the Right to Information bill have a problem with this. It says the EC's excuse falls flat in the face of Section 27(1) of the RTI Act 2019, Act 989. It continues to say that that Section 75(2), and you remember the EC quoted Act Section 75(1) of the RTI bill. Now, the coalition for the RTI is also quoting the same Section 75, but chooses subsection 2C of the Act, which provides that a fee shall not be payable for the reproduction of information which is in public interest. And it says that the MP's request was in the interest of the public, and so it has problems with the EC's response to the MP's request for information. Now, it says the refusal by the EC is a missed opportunity for that entity to strengthen its democracy. Let's look at more concerns that the RTI coalition is raising. It wants the president, as a matter of urgency, to put together to establish the RTI Commission and also appoint first members of the board of the commission. Remember, that commission is also very important for the full implementation of the RTI law. When the conversation gets into full swing, you will understand why that commission is very important. So tonight on PM Express, we're exploring the new phase of the struggle for implementation of the RTI law. You know how long we fought for this law to be passed. And after it's been passed, and now that we're supposed to be enjoying, we're still struggling to have it implemented. I'll introduce to you my guests after this break. Live on PM Express, my guest in the studio, Sam Nate George, is member of the Communication Committee of Parliament, and also joining me in the studio is Samuel Bing, member of the RTI Coalition. He's also Executive Director of Parliamentary Network Africa. Good to see you, gentlemen. Pleasure. Also on Skype is MP for Ashaman, and it's Henry Nogbe, the man at the center of this whole controversy. Good to have you, Honorable.
opportunity of viewers.
And also Samson Ladianyanene will also be joining us on phone. He's a private legal practitioner and a member of the RTI Coalition. Good to see you all, gentlemen. And I'd like to start with you, Honorable Ernest Henry Nogbe, who's MP for Ashaman. I want you to bring us to speed. Specifically, what was your request to the EC that necessitated this response from them?
Well, thank you very much, and good evening to your viewers once again. My request to the Electoral Commission is in respect of document information that I wanted to get from them, because I realized that something untoward. So I caused my lawyer to give us better particulars concerning these procurement breaches. We have in our proposals the Part 6 of the Procurement Act state that if you want to engage consultants, you need to follow certain procedures, certain processes, which I realized that the Electoral Commission did not. But to give them the benefit of the doubt, we have a right to them to seek the first-hand information. But unfortunately, they declined to this information.
I'll come back to you, Honorable. Stay on there for me, but let me gauge the mood of Sam George. The EC was specific on why it is not able to provide information for your colleague, and it provides or cites Section 75(1) of the Right to Information Act 2019, Act 989, and it says that because of that, it cannot provide information, and that provides that there are charges and fees that should be determined by Parliament, which should be paid for requesting for information. And the EC says it is unable to deal with that problem because Parliament has not yet determined how much should be charged for information and what have you. That should settle the case, isn't it?
Let me say a very good evening to our viewers, and to your good self, Aisha, and to my colleague here, and to Ernest on the line. You have an electoral commission that appears to be messing up everything that they are involved in. I mean, they're messing up the register issues, they're messing up everything they have to do, and now even a simple RTI request, the EC is fluffing his lines. We need to look at our EC properly. The EC's response is in blatant and flagrant disregard for the dictates of the RTI, Act 989. I'll tell you why. The EC caused a response to be written by their lawyers, Amenuvo and Associates. Now, if you take Section 19 of the Act, Section 19 of the Act says, person to deal with application. I read, an application to access information shall be dealt with by the information officer of the public institution.
Okay.
Amenuvo and Associates are not the information officer of the Electoral Commission.
But the Electoral Commission is their client.
No. The law is specific on who should respond.
Okay.
The law knows that public institutions have lawyers.
Okay.
It did not say your lawyer should respond. It said the information officer should respond. So this response from the Electoral Commission should be put in the trash can. And we must tell the Electoral Commission they don't know what they are saying. Now, I'll take you again to what the law says as to how you need to make a decision.
Okay.
Decision on application, Section 23. Where an application for access is received by a public institution, the information officer shall take a decision on the application and shall send a written notice to the applicant within 14 days from the date of receipt of the application. 2, and this is important, the notice shall state, A, whether or not access to the information will be given. This bogus response from the lawyers does not state whether access will be given or not. B.
Well, I have the letter here, and it gives an indication that it will not. I think it states that it gives an indication. Okay, so the EC says the excuse that the EC. Okay. So this is the RTI.
I can read the
Coalition.
EC's letter.
The
EC's letter says, and I can take you to the last paragraph. It says, as ready and willing as our client is to provide the information requested by your client, it is not immediately able to do so because the fees and charges applicable are yet to be determined in accordance with the law. This in itself is not a legal response that says, yes, we will give it to you. It says they are willing. Being willing to give something is not the same as saying we will give it to you. So they have failed on the first test of even what 23.2 says. A. 23.2b says it must also state the notice and the notice, when we say the notice in the law, we are responding to the response to the application. First, it says A, whether or not access to the information will be given. B, whether access to only a part of the information can be given and the reason for giving only that part. This letter is silent on that. Because if you listen to Honorable Ernest Nogbe, my colleague, he asked the question in two parts.
Yeah.
Did you consult, did you contract this person to offer consultancy? And if you did you follow the Public Procurement Act?
Yes.
So we need to know whether they'll be in a position, this notice should have stated whether they're in a position to answer both sides of the question or answer one part, and a reason why they will not be in a position to answer the other part. This notice fails to do that.
Okay.
Bogus response. 3, where the information officer decides to give access, the notice shall state A, the form or manner in which the access will be given. This has not stated the form and manner in which access will be given, if they will be given access.
Okay.
B, whether access is to only a part of the information because the other part is exempt information, it doesn't state that. C, the day on which the public institution expects the information to be published or submitted. In the case of a deferred access under Section 22, it is silent on that. D, the prescribed fee for the reproduction of information. So it then tells you that this response that has been given, 1, the lawyers for the Electoral Commission are as incompetent as the Electoral Commission itself. Because if the lawyers were competent, they would have read the act and known that you cannot give the fees and charges not being set by Parliament as a reason to say you cannot process. The law says answer and say we will be able to give you. If we can give you, we'll give it to you in full or in part. We will give it to you on so and so day, and this is the fee. That is what this original response must be. This original response must not come to this place. Now, I've read what the coalition is also saying. Let's go to that place. 75.2.
Yes.
Because they quote 75.1. 75.1 says fees and charges. It says an applicant seeking access to information shall under this act shall pay the fee or charge approved by Parliament in accordance with the Fees and Charges Act 2009.
Yeah.
We passed the Fees and Charges Act in November. Unfortunately, when the LI and things were done, at that time the RTI had not been fully completed, and so there was no consideration for the Fees and Charges Act. For the RTI under the Fees and Charges Act. However, what again, the lawyers for the Electoral Commission, who are equally as incompetent as the Electoral Commission itself, fail to read is that there is a 2, section 2 to 75. It says, despite subsection 1, a fee or charge shall not be payable for A, reproduction of personal information of the applicant, B, reproduction of personal information of a person on whose behalf an application is made. What is most important in this case is C, the reproduction of information which is in the public interest.
Okay.
This question is a public interest question. If the Electoral Commission has contracted a consultant, and we want to know if they have done it using the public procurement laws, this is public interest. It is fee and charges exempt. So whether there is a Fee and Charges Act that covers the RTI or whether there is none, it is inconsequential. The processes for response to a request have been bogusly malhandled by the EC and its lawyers. And 2, the reason they give is not founded in law.
You were a member of the committee that worked on
this bill
before it
even became law.
What was the spirit behind the fees and charges? I think I'll come back to that. But let me get you in, Sami, on this one. The RTI Coalition is certainly not happy about this. But of course, if you listen to the Electoral Commission and listening to Honorable talk about all the processes that they have breached, he did not say that 75.1 does not exist. What reason, what does the 75.1, what's the purpose of that provision in there? If you look at that provision and look at where you're also coming from, where lies your concern as a coalition?
Okay, thank you very much. And it is important to note that the purpose for 75.1 in the law, was purely to ensure that public institutions don't go. I mean, the reason why Fees and Charges Act comes in is to ensure that public institutions don't go quoting, for the want of a better word, ridiculous prices and fees that scare people away. So these things are regulated by, acts of parliament. But, we have stated as an RTI coalition that we think this particular excuse that the Electoral Commission and its lawyers give to why they are unable to provide information to a citizen of the land, the Honourable Member of Parliament for Ashaman, Mr. Nogbe, is a reason which we classify as unfortunate and one that we see as a clear demonstration of some lack of understanding of the law by the lawyers of the Electoral Commission. And we pointed to something specific also in 27.1. And as a coalition, we thought that this was very, very important. The law in section 27.1 says that a public institution may refuse access to information if there were two conditions.
Yeah.
Two specific conditions under which you can refuse access to information. One, if the application is manifestly frivolous or vexatious, or two, if the information is an exempt information.
Okay.
If any of these two, reasons does not come to play, really,
you have no reason.
You have no reason to refuse, access to information based on fees, based on your own intuition or whatever it takes. I mean, even based on the fact that you don't have an information officer in your institution. That does not give you reason why the citizen of the land must suffer for a law that has come as a result of a constitutional right that has already been provided to all of us, as citizens of the land. Now, it is important also to note that for an institution like the Electoral Commission, who quite recently, in meeting up with civil society on the brouhaha that has, recently come up, with the commission, stated continuously that they are open to ensuring greater level of transparency, and openness and what have you. We thought that this was a fine opportunity for them to show that this is an institution that is willing to accept, assert itself within the virtues of transparency and openness and all of that. And for us, this really flies. This response to Mr. Nogbe's request for information flies, fast in the face of what we expect. And the reason why we have come strong at it is that we do not expect that this becomes a precedent. That all public institutions in Ghana between now and whenever the fees and charges bits regarding RTI comes to play will just give us the straight line and say that because there is no fees and charges, you cannot we cannot respond to you because we cannot know how much we should charge you for this. And we think that the Electoral Commission need to know better. Their lawyers needed to have advised them better on this particular situation. And it's unfortunate that it has come to this.
All right, Samson Ladi Anyeni is a private legal practitioner. He's also a member of the coalition, the RTI Coalition. Good evening to you. Thanks for your time on PM Express.
Good evening, Aisha.
How does it come across to you that after all the struggle to pass the RTI bill and after successfully getting presidential assent, citizens are still facing challenges with access to information?
Okay, so to start with, I listened to Samuel Nete George, the Honourable Member of Parliament, and I will endorse fully the technical points that he raises, and I would urge all of us to pay particular attention to the technical points that he raises. The law was made so that people do not continue to make expenses in seeking public information. So by the making of this law, you don't need a lawyer to be the one to make your application for you. The law says even if you are illiterate, you can't read, you can't write, all you need is to walk up to the particular institution you seek the information from. You will be guided to say what you want orally. the information officer that St. George mentioned, who must be designated at the particular of agency or organization as the one to receive your information request, will reduce your oral submission into writing, get you to sign or to thumbprint. They will make copies, hand a copy back to you, and then they will treat it as required by law. If the information officer, within the 14 days window he has to deal with your request, and within the 48 hours that he has to deal with your request, if it has to do with the safety of an individual, indicate that the information is exempt, or for one reason or the other, you cannot have the information and you are denied access to the information, you have a right to make what is known as the internal review. And then the head of the institution will now do that review and in a matter of some 7 days, determine whether you ought to be giving, you will receive or you will not receive. The process will continue where the RTI Commission may even come in. Now, as we speak, the RTI Commission has not been set up.
Yeah.
The 7-member commission has not been set up. So the first point is that this is a situation where someone takes the information they are looking so seriously that they use a lawyer to make the request. You have no business using a law firm to be replying to that request. You are required by law to have designated your information officer in your entity. The EC has not done that. If it has done that, the right thing to do was not to refer it to a lawyer, and for the lawyer to take this technical approach and on the advice of the EC, do what I say is very shameful and a missed opportunity to indicate respect for the citizens whose monies the EC has used to generate the information that they are requesting. And this is not an ordinary member of the public. This is a member of parliament who is representing people in that parliament. If they make a request for information, you have no business treating the information as if it were your personal property generated with your private funds. The information is generated with the public money. Now note, Aisha, that the elections we are to run this year is to be run purely with government of Ghana money. That is your tax. That is my tax. The officers at the Electoral Commission, it is my tax that pays them. I have given them a job to do. The computer that they use to generate information, I bought it. It's my money. The meetings they hold to have discussions for the purposes of generating the information that the honorable member requested, I pay for those meetings. I pay for the fuel that they drive into those meetings.
Certainly, the law must be allowed to work. I would have to take a break here, but when I come back for purposes of education, we definitely have to go more into this. But more importantly, to find out what was the reason why 75(1) was put into this law. The committee that worked on it, didn't they envisage that this challenge will pop up with this law? Why was it deliberate that the fees and charges were left even as we were told that in January, this law must begin to work and citizens must ensure that, or citizens can actually go and look for information through this law. When I come back from this break, we'll find out all of that. We're still live on PM Express and we're discussing the RTI law. We're all happy when the president assented the bill, and we're told that it will be fully operational in January 2020. So any citizen can go and request for information. This is the first test, and the first test has been met with resistance. People think that the EC is deliberately hiding behind this act or section of Section 75(1) of the RTI Act to deny citizens access to information. Whatever it is, Sam George, you're a member of the committee that passed the law, and the committee that worked on this document before Parliament generally passed this act into law. There's a reason why the 75(1) was put there. And before I went on that break, I was asking the question whether you deliberately did not determine the fees and charges. Did you even envisage that people could hide behind this to deny information? Why hasn't it been determined so that, and even why did you even put it there in the first place?
Okay. We had extensive, I remember this fees issue was an issue we deliberated on at the committee level for almost 2.5 hours in Koforidua. This particular clause, 75, on fees and charges. And when it came to Parliament, when it came to the plenary, it was again debated for over 30 minutes in the plenary. The argument is simple. Some information will be extremely voluminous, okay? And there is cost to the reproduction of this information. You cannot say that an institution should bear the full cost of the reproduction. The person who is making the request must be in a position to cover the administrative cost of reproduction.
That is if it is not of public interest.
That is if it does not fall under 75(2).
Okay.
If I am writing to Parliament, if me, Sam George, Member of Parliament for Ningo Pram Pram, if I do an RTI request to Parliament today on information about me, it is exempt, it's free. Because it says, despite subsection 1, a fee or charge shall not be payable for the reproduction of personal information of the applicant.
Okay.
So if I'm requesting for example, all commentary from the Hansard of my entire 3 years, 1 month, or 3 years, 2 months in Parliament, I want a copy of everything that the Hansard has captured me saying. Parliament is bound to reproduce that information free of charge for me because it's an application about myself. If somebody makes a request like Ernest has done, which has public interest, again, it is exempt. So this whole 75(1) is supposed to cover instances where, take for example, I write to, and I give that example, I write to multimedia and say that I want to know what your dismissal policy under your, what is your dismissal policy under your human resource department? How do you fire your anchors if there's an issue? That is not a public interest issue. It is not related to me. If I want Joy FM to produce or reproduce your HR policy subject to dismissals, I would have to pay you for the cost, administrative cost of reproducing that document. That's all 75(1) is talking about. In fact, if you look at the 75(2), 75(2)(e), and you see, that's why when you read 75, you read 1, but you must read 2. 2 is expressed in all of the things it says. Look, even if the issue is subject, even with the example I've given, where I want information from Joy FM, which is not of public interest, but I am able to prove to Joy FM that I am so broke I cannot pay for the information. 75(2)(e) says if information to an applicant, despite subsection 1, a fee or charge shall not be payable for information to an applicant who is indigent. Meaning if I am poor. In fact, F says you would also not charge if the person who is requesting for the information is a person with disability. All of this are stated because we're trying to create as much safeguards to ensure that we do not monetize the access to information and make money a barrier to the access to information. The reason why there is no fee and charge set for the RTI is very simple. The Fees and Charges Act, as amended in 2019, was done in November of 2019. It was laid sometime, I think, if my memory serves me right, towards the end of September 2019 and matured and was passed by Parliament in November 2019. At that time, the RTI, by the time the submissions, because don't forget the Fees and Charges Act is passed, but an LI is passed subsequent to the Fees and Charges Act. Now the LI spells out all the various state agencies, universities, Ghana Police Service, any government agency and the fee they charge must be approved by Parliament. No state agency can charge the public a fee without Parliament approving it. So the LI spells out every agency. Now, Ministry of Finance opens a window middle of the year, between May and August, for every institution to submit their fees and charges to it, for it to prepare into an LI and bring to Parliament. In May, between May and July, when the window was open for fees and charges, you did not have an RTI bill. Or you had an RTI bill, but there was no commission.
Yeah.
It had not been, the president had assented, but had not come into effect. It came into effect on the 1st of January this year. You don't have a commission that would have submitted its fees and charges to the Ministry of Finance. And so, look, two things here. First and foremost, the president must give, to cure this malaise, the president must take initiative. The president must show us that he did not just pass the RTI and accent it into law just for the showbiz of it, but he really means it.
But whose duty is to, before you make that point, whose duty is it to determine the cost and the fees?
They would submit, the agency that would charge the fee would submit it to Finance, and Finance will bring it to Parliament for approval.
That hasn't happened.
And that's what I'm saying. The president has not even set up the RTI Commission. For the commission to be able to, in conjunction with the Ministry of Information, present its fees and charges to the Ministry of Finance, for the Ministry of Finance to bring that to Parliament. And there are time frames for this. So the next time there is going to be a consideration or a change of the fees and charges is in November of 2020. November of this year. But what we are saying is, if the president is so minded and committed to RTI and the access to information of Ghanaians, the president can instruct the Minister for Finance to work with the commission after he set up the commission and the Ministry of Information to come to Parliament and get Parliament to pass a stand-alone LI for the RTI Commission. Parliament has the power to not wait till November, to tomorrow, if they bring us a stand-alone LI to pass and approve the fees and charges for implementation of the RTI, Parliament can do that. So if the president can bring us tax waivers for his in-laws hotel under a certificate of urgency, effectively being the first business of the meeting of this house, the president can as well bring us fees and charges for us to give to RTI, so that the Electoral Commission will not do what the Act says should be the grounds for refusal in 27. Because this letter from the lawyers for the Electoral Commission is manifestly frivolous and vexatious.
Well, I think I would want to look at how dangerous the absence of the commission is to the implementation of the RTI law. But before I went on that break, Samson was making a critical point of the fact that the citizens, the government is accountable to the citizens. Everything they do is with the taxpayers' money. So they have no reason to deny citizens information. But will anyone suffice to say that after all said and done, we're still back to square one? Reason being that the law is not fully operational, even though the president has assented it. And until the said commission is set up, the cost for information determined, blah, 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 citizens will not be able to fully access information through this law.
Is that question to me?
Yes, please, Samson.
Okay, so number one, let's start from here. Look, let's not buy this deception and simple conduct by the Electoral Commission. Let's not buy it. Read Section 28 of the Act. By Section 28, there is not only one format by which you can give information which is requested. In fact, the first form by which you can give information which is requested is to give the person who is requesting the information a reasonable opportunity to inspect the information. Did you hear that?
Yeah.
Inspect the information. How much fees do you need for the person to come and inspect the information? So let's not give them the opportunity to write on the back of this shameful conduct an insult to the public whose money keep them in those offices and whose money they have used to generate the information. Check this. I have sat in meetings where the Electoral Commission, by its chairperson, told journalists and the public that they are ready and willing, and that the process that this MP is seeking information about, they will open it fully to the public. And that every step of the way of the procurement, they will let the public participate. Everybody will know everything that is going on. What do they have to hide? And therefore using fees to try to stifle or to deny the MP the information he has requested.
Certainly there must be a remedy for this, and there must be a way of the citizen holding government.
There is an internal review that once the information officer takes the first step and denies you the information, you now go to the internal review where the head of that institution will conduct the process of the internal review to either agree with the information officer or disagree with the information officer and give you the information. And there is a commission where the commission can now also take a decision which may be affirming the decision given by the information officer or the internal review. And the last resort is to go to court, which we sought to avoid by making sure that we have an act which will help us so that we don't go to spend money in court.
Yeah.
Now, if you use your lawyer to do the process, what is the review process? So in the first place, this is flawed. Information officer did not deal with the process. It's flawed. So the request should be deemed as not having even been treated yet.
Absolutely.
But you see, in the end, it's going to be a matter of going to court. And this man has to now spend money to go to court. This is what we have to avoid. And I say this moment that the government, particularly the information ministry, and the president must be heard on this. They must not wait for anybody to ask for their commentary. They should make a statement discouraging all government agencies and appointees who are in a position to get information when requested from taking this posture, which is very shameful.
Unfortunately, we tried to get the information minister to join in this conversation, but he could not join the discussion.
The information minister in January told Joy Super Morning Show, that anybody can begin the process of applying for information.
True.
And that they shouldn't wait for an RTI commission. And
Correct.
that if they apply, it will be ready. They should immediately make a statement, very strong statement, to discourage any public officer or any agency from taking this kind of posture. Except the information is exempt and except the application is frivolous, it must not go through this process. It is not only by way of giving copies that information can be received.
I'm grateful that you joined us. Samson Ladianyinine is a private legal practitioner and he's a member of the RTI Coalition. Hopefully, we're waiting to hear from the Information Ministry because this is right under his umbrella, and it will be refreshing to hear the Information Minister, all the presidents, speak on this matter. Before I went to something, I wanted to find out something. How dangerous or how urgent is this commission to the implementation of the RTI law?
Right, it is very urgent, and even now the more, because the Information Commission, first of all, is supposed to serve as an adjudicating body of a sort. When people have been denied, information from a public institution, they've gone to the information officer, it has been denied. They've gone through the internal review process by applying to the head of that institution, they've been denied. They now have two options, either to go to the High Court or to go to the Information Commission. Samson had already spelled out how expensive it would be for ordinary Ghanaians to go to the court, and so the Information Commission becomes your best point of call to be able to ensure that your right is not trampled upon. Now, in January first week of January, the Information Ministry came out, talking about how, well, if anybody even applied for information on the 2nd of January, it will take 14 days before the information will be provided, and before they go through all of the internal review process, we would have already had the Information Commission present. We are in the middle of the month of February. The commission is not available. The first members of the board, are not available. And we find this as very, very unacceptable, the RTI Coalition, because the RTI Commission and the members to serve on the board should be in place now. Honorable Nogbe would have an opportunity to actually take his case to the RTI Commission presently to be able to seek some level of redress. So it is important. That doesn't exist currently. Apart from they even adjudicating matters, the Commission has a responsibility to do public education so far as the law is concerned. They have a responsibility to train RTI officers and what have you. These things are not in place. Not only is that the only dangerous point, the Information Ministry also, issued a release and went to town about the fact that information officers have actually been appointed for all of the ministries, but for the remaining departments and agencies, there are people designated, for now for them to do the work. The example from the Electoral Commission, clearly shows to us that the Information Ministry was not being very transparent with us on this particular matter, and it hasn't proven that there is actually an information officer, because if there was somebody, unless of course they are trying to tell us that the attorneys Amenuvo and Associates are the Electoral Commission's information officers. That would be very strange, for anybody to take. So yes, government has a responsibility to, as a matter of urgency, ensure that the Information Commission is set up. The delay is becoming, too costly for the people of Ghana, and we must hear from the government, the executive branch, and particularly the Information Ministry. Just like Samson said, the ministry that is currently supposed to be shepherding the process cannot be silent when the very first test of the RTI Act is faced with such,
so Parliament has a lot to do, and I'm going to find out how Parliament is going to push this agenda, because I'm not sure Parliament's work ends at just passing the law. Implementation should also be a concern to Parliament. Honorable Nogbe, let me bring you in briefly. The commission to review your issues is not in place. What next is your strategy to get your information?
Well, thank you. My sister, I think the response from the Electoral Commission is upset, and comes from a former secretary of Ghana Bar Association. I find it very intriguing that we come out with this. Let's granted that Parliament has made a mistake, or maybe did not pass the law. Granted. Why am I to punish for that? Why should the scene of Parliament be visited on the stand? There are a lot of Supreme Court cases that came out to a ruling of Supreme Court came out to say that the scene of Parliament should not be visited on individuals. So if at this point, Leonard, let me say, the lawyer for the Electoral Commission will not read through the line to even see that Article 21F of the 1992 Constitution supersedes that of the RTI law, then we have cause to worry. We have Section 28 of the Procurement Act that states that all institutions, all public institutions must keep records of procurement transactions. And so, therefore, any individual institutions to get those information. So, if we are behind the fees and charges, not by Parliament for that matter, the best they could have done is to give me this information for free. Before the information law, we were still requesting for information from these public institutions. So I'm just surprised that this is from a lawyer.
Again, this letter doesn't even suggest that the EC has dealt with your request. It means that you can still go back and request for that information. Parliament needs to do a lot, especially your committee, the Communications Committee in Parliament. How are you going to push that this commission that we say is very urgent to ensuring the full implementation of the RTI law is put in place?
Actually, it's easy for everybody to hold Parliament responsible for the sins of other people. This has nothing to do with the Communication Committee of
Do you
Parliament.
feel it's deliberate? Is a deliberate attempt to stifle information?
Aisha.
That's why the commission has
Aisha.
not been put in place?
I do not know the mind of the president. I cannot sit here and purport to speak for the president or his Minister for Information. However, all I'm saying is that if the president can act expeditiously, and on the first day of the resumption of this meeting of Parliament, the fourth meeting, or the first meeting of the fourth session of the Seventh Republic of the Seventh Parliament of the Fourth Republic of Ghana. If you take our order paper, for it was Tuesday 28th, I think, of January. If you take the order paper, the first item of government business was the approval of $23 million for Akufo-Addo's brother-in-law's hotel as tax waiver. Urgent business. I'm saying that the president must use half of that kind of urgency to set up the RTI Commission and get Parliament to work expeditiously on an LI for the RTI for fees and charges. Because tomorrow, a request may go that may not be public interest, but the citizen must not be stopped because Parliament has not been able to pass a fees and charges act. Parliament on its own cannot generate a fees and an amendment or an LI to the Fees and Charges Act. That must come from the Ministry of Finance. The Minister of Finance answers and is an appointee of President Akufo-Addo. The RTI Commission must be set up by the President in consultation with his Minister for Information. Information officers must be put in every government institution at the behest of the Ministry of Information and the RTI Commission. Who does the Minister for Information answer to? President Akufo-Addo. Ultimate responsibility in this matter, in getting this RTI Act that we have passed, to not be just a fine piece of paper on the shelves of libraries and law faculties, is for the president to give action to the bill he's assented to. What the president has done now is to tell you that he's bought you a car. He's taken off the tires of the car. He's made sure that they've disconnected the fuel tank to the engine, and has told you to drive the car.
I think it's very urgent for the president to come, and I'm grateful for your time. Sam George is MP for Ningo Pram. Samuel Obeng is Executive Director of Parliamentary Network and also a member of the Coalition of RTI. Honorable Ernest Nogbe is a member of Parliament for Asham, and I'm grateful that you watch us. My name is Aisha Ibrahim. Have a great one.